In the fall of 1957, a 15-year-old girl put on her best white dress, picked up her school books, and walked toward a crowd that wanted to kill her. Her name was Elizabeth Eckford. She was one of 9 black students selected to be the first to integrate Central High School in Little Rock, Arkansas. And on September 4th, 1957, she walked to that school alone because the message about the group meeting point never reached her. What she walked into has never fully left American memory. Hundreds of white students and parents surrounding her, screaming into her face. Arkansas National Guard soldiers sent by the governor blocking the entrance. Not to protect her, to stop her. The photograph taken that morning is one of the most recognized images in American history. A girl in a white dress, textbooks clutched to her chest, walking through a wall of hatred, her face composed in a way that looked almost impossible. She didn't get in that day. None of them did. That was September 1957. In the spring of 2025, the Trump administration deployed National Guard troops to Los Angeles, then Chicago, then Washington, D.C., Memphis, New Orleans. By July of 2026, 5,000 troops were stationed in the nation's capital for what the administration called security operations during the 250th anniversary celebrations. A federal judge ruled in September 2025 that the Los Angeles deployment violated the Posse Comitatus Act, the federal law specifically designed to prevent the military from operating as domestic police on American soil. The administration appealed. The troops stayed. The debate that followed went exactly where you'd expect. One side said, "The president is enforcing the law." The other said, "The president is becoming the threat the law was designed to stop." And then someone noticed something. The last time a president deployed military forces into American cities at this scale, the legal mechanism was almost identical. The arguments from Washington were almost identical. Even some of the words were the same. But the direction was completely reversed. This is that story. In the summer of 1954, the United States Supreme Court issued a ruling that changed the country. Brown versus Board of Education declared racial segregation in public schools unconstitutional. The separate but equal doctrine, in place since 1896, was dead. The court followed up in 1955 with what became known as Brown II, ordering schools to desegregate with all deliberate speed. The American South did not comply. Orval Faubus was the governor of Arkansas. In 1957, he was facing a difficult re-election campaign, and the politics of Arkansas were moving in a dangerous direction for anyone who appeared soft on integration. Faubus had not been a particularly extreme segregationist before. He had even appointed black Arkansans to the State Democratic Committee, a notable gesture at the time. But by the summer of 1957, the political pressure was intense. White citizens' councils were organizing across the South. Politicians who hesitated were being replaced by ones who didn't. Faubus watched the electoral map and made a calculation. Little Rock had actually been making modest progress toward integration. The school board had developed a careful, gradual plan. 9 black students had been selected, academically strong, emotionally resilient, capable of surviving what everyone around them knew would be an extraordinarily difficult situation. The woman who coordinated almost everything was Daisy Bates. She was the president of the Arkansas NAACP and the publisher of a black newspaper in Little Rock. She and her husband had been receiving death threats for years. In the weeks before school started, she held strategy sessions with the 9 students and their families at her home. She rehearsed them on how to walk, how to respond to being struck, how to keep moving when every instinct said to stop. She had a phone tree set up to coordinate the group's arrival on the first day. That phone tree failed to reach Elizabeth Eckford, whose family had no telephone. Elizabeth found out what had happened to her on the bus ride home. What Daisy Bates had prepared those 9 students for was not an event. It was a sustained campaign. She had worked with the NAACP's legal team and with sympathetic school board members to identify students who could hold up under conditions that no child should face. The criteria were not just academic, they were psychological. Could this person be spat on and keep walking? Could they absorb a blow and not retaliate? Could they come back the next morning? Bates knew that a single incident of retaliation would be used to discredit the entire effort. The 9 students were not just going to school. They were carrying the legal strategy of a civil rights movement on their shoulders. The 9 students were Minnie Brown, Terrence Roberts, Elizabeth Eckford, Ernest Green, Gloria Ray, Jefferson Thomas, Carlotta Walls, Thelma Mothershed, and Melba Patillo. They would become known as the Little Rock Nine. On September 2, 1957, the night before school was scheduled to begin, Governor Faubus went on television. He announced that he was deploying the Arkansas National Guard to Central High School. His stated reason was public safety. He claimed to have received information that groups of white supremacists were converging on Little Rock, and he needed the Guard to maintain order. He did not say which side the Guard had been ordered to protect. That became clear the next morning. On September 4th, Elizabeth Eckford arrived at Central High School alone. She had dressed carefully. She carried her school things. The National Guard soldiers were at the entrance. They let the white students through. They stopped her. She tried another entrance. Stopped again. The crowd behind her began to grow. People were screaming, threats, slurs, things a teenager should never have to hear. A white woman named Grace Lorch found her and sat next to her at a nearby bus stop, shielding her as best she could until she was able to leave. Lorch later said she was frightened the entire time. She didn't move. Elizabeth Eckford got on a bus and went home. The other 8 students arrived separately and were turned away as well. Governor Faubus had used the Arkansas National Guard, state military forces, not to maintain order, but to enforce his own defiance of a federal court ruling. The soldiers standing at the entrance of Central High School were there, in effect, to uphold segregation. A federal judge issued an injunction ordering Faubus to stop blocking the students. Faubus ignored it. The Justice Department went to court. Legal maneuvering continued through most of September. On September 20th, the federal judge ordered the National Guard withdrawn. Faubus complied, technically. He removed the guard. He left the school with no protection and announced that the students should return. On September 23rd, they did. The mob outside the school that morning was larger than anyone had anticipated. People were trying to break through police lines. Local law enforcement was overwhelmed. Inside the building, the 9 students were rushed through the school and eventually out through a side entrance for their own safety. A reporter for a local radio station announced live on air that the black students had entered the school. Within minutes, the crowd outside turned violent. People were chasing black journalists in the streets. The situation had become something that could not be controlled by municipal police. That evening, President Eisenhower watched what was happening in Little Rock. Eisenhower is a complicated figure in this story, and it matters that we understand him clearly. He was not a passionate supporter of desegregation. He had privately told a friend that he believed the Supreme Court's decision had set back progress in the South by 15 years. He had been cautious, even reluctant, throughout the summer as the situation in Arkansas developed. Earlier that year, he had met with Martin Luther King Jr. and asked him to urge Black Americans to be patient. He had not wanted to be in this position. There was also the international dimension. The Cold War was at a peak. Soviet propaganda outlets had been broadcasting the images from Little Rock across Asia, Africa, and Latin America. Here, they said, is what American democracy looks like. What was happening on the streets of Little Rock was not just a domestic crisis. It was, in the eyes of the Eisenhower administration, a national security problem. The United States was asking newly independent nations around the world to choose the American model over the Soviet one, and those nations were watching a black teenager be chased from a schoolhouse by a mob. All of this weighed on Eisenhower when he made his decision. On the evening of September 24, 1957, he addressed the nation from the Oval Office. He did not speak about civil rights as a moral cause. He spoke about order, about law, about the authority of federal courts. He said that disorderly mobs were defying court orders. He said the image of America abroad was at stake. And he said, "Mob rule cannot be allowed to override the decisions of our courts." The next morning, 1,000 soldiers from the 101st Airborne Division arrived in Little Rock, Arkansas. The Screaming Eagles, the same division that had jumped behind enemy lines at Normandy, that had held Bastogne in the snow, were now standing in an American schoolyard. Eisenhower had also federalized the entire Arkansas National Guard, removing it from Faubus's command entirely. The same soldiers who had blocked those 9 students 3 weeks earlier were now under orders to protect them. On September 25, 1957, federal soldiers escorted black children to school on American soil for the first time since Reconstruction. Each of the 9 students had a soldier assigned personally to them. They walked through the front entrance of Central High School. But the entrance was not the hardest part. Inside the school, the harassment continued every day for the entire year. Melba Patillo had acid thrown in her face in the hallways. Jefferson Thomas was kicked and beaten. Minnie Jean Brown, after months of sustained torment, poured a bowl of chili on a student who kept blocking her path. She was suspended. She was later expelled after a confrontation in which she responded to a shove, not with force, but with words. When she left, some of her white classmates circulated cards that read, "1 down, 8 to go." The soldiers guarded the exterior. Inside, the 9 were mostly on their own. There were individual white students who offered quiet acts of decency. A shared look, a note passed without explanation. Those students were socially destroyed for it, ostracized, threatened, called traitors. The 101st Airborne remained through the end of the semester. A reduced force stayed into the following year, but their numbers shrank as the administration tried to de-escalate. By the spring of 1958, the 9 were navigating Central High largely without military protection. Terrence Roberts was knocked down the stairs. Gloria Ray was pushed into a locker hard enough to leave a bruise she didn't show anyone. Carlotta Walls had her locker broken into repeatedly. Thelma Mothershed, who had a serious heart condition, was told by classmates that they hoped she would die at school so they wouldn't have to see her anymore. The school's principal did not expel the perpetrators. He documented the incidents, filed the paperwork, and left the 9 to get through the day as best they could. What the country saw from the outside, federal soldiers, a resolved crisis, integration proceeding, was not what the 9 were living from the inside. Ernest Green graduated in May of 1958. He was the first black student to earn a diploma from Central High School. Martin Luther King Jr. attended the ceremony. Green later said that walking across that stage felt like proof that they had not been broken. Governor Faubus responded by closing all 4 Little Rock high schools for the entire 1958 to 1959 school year. More than 1,500 students, white and black, spent a year without a school to attend. Parents scrambled. Some enrolled their children in districts outside the city. Some arranged correspondence courses. Some simply waited. They called it the lost year, and the students who lived it carry it still. Here is the part of this story that often gets omitted. Orval Faubus was re-elected governor of Arkansas in 1958, and then again in 1960, and in 1962, and in 1964. He served 6 terms in total, becoming the longest-serving governor in Arkansas history. The stand he made at Central High School did not end his political career. It extended it by a decade. Of the 8 students who did not graduate from Central High, most finished their education elsewhere. Several had to leave Arkansas entirely to do it. Melba Patillo finished high school in California. Minna Jean Brown went to Canada. Jefferson Thomas and others eventually earned degrees after years of disruption. They had each been asked to sacrifice a normal adolescence for a legal principle. Most of them spent the rest of their lives being asked how it felt. Most of them gave the same careful answer. It was necessary, and it cost more than anyone outside those halls could fully understand. The legal authority Eisenhower invoked was the Insurrection Act of 1807. The law gives the president broad authority to deploy military forces domestically when state governments are unable or unwilling to enforce federal law or protect constitutional rights. It is one of the oldest tools in the presidential arsenal, and one of the most rarely used because of what it signals to use it. Eisenhower had not wanted to invoke it. He did anyway, because the alternative was allowing a mob to nullify a Supreme Court ruling on American soil, now move forward 68 years. In the opening months of 2025, the Trump administration launched what it described as the most extensive immigration enforcement operation in American history. The National Guard became a central instrument of that effort. Deployments to the southern border drew relatively little legal controversy. Presidential authority at the border is broad and well established. But then the deployments moved into cities. Los Angeles was first. The administration's argument was that California's sanctuary policies, which directed local law enforcement not to cooperate with federal immigration agents, were obstructing federal law. The response was to send in National Guard troops operating under federal authority to assist directly with enforcement operations. The legal structure of these deployments matters. When the president federalizes National Guard troops under what is called Title X authority, those troops operate under federal command, outside the control of their home state governors. They are no longer state soldiers. They become, functionally, federal forces operating on domestic soil. It is the same mechanism Eisenhower used in 1957. The legal vehicle is identical. What changes is who is giving the orders and what those orders say. California's governor objected. Los Angeles's mayor objected. Officials argued the deployment was illegal, politically targeted, and violated the principle that the military does not operate as domestic police in American cities. The legal debate centered on the Posse Comitatus Act of 1878. The law prohibits the use of federal military forces for domestic law enforcement purposes. There are exceptions, the most significant of which is the Insurrection Act. The administration argued the deployments were authorized. Critics argued they were not. In September 2025, a federal judge sided with the critics and ruled that the Los Angeles deployment violated Posse Comitatus. The administration appealed. The troops stayed. By the summer of 2026, National Guard forces were operating in multiple American cities. The July 4th weekend in Washington, D.C., the 250th anniversary of the Declaration of Independence, saw 5,000 troops deployed in the capital. The images circulated internationally. Legal challenges were multiplying. The underlying constitutional question, how far presidential authority over domestic military deployment actually extends, and under what circumstances it can be checked, remained unresolved in the courts. Let's put 1957 and 2025 next to each other. In both cases, a president deployed military forces into American cities. In both cases, the stated justification was that state or local authorities were defying federal law. In both cases, the legal vehicle was the same framework: presidential authority to federalize forces and deploy them domestically when civilian authority breaks down. In both cases, a significant portion of the country believed the president was right, and a significant portion believed he had gone too far. And in both cases, the president's critics argued that the military deployment was itself a form of government overreach against the very people the government was supposed to protect. Here is where the comparison gets complicated. In 1957, the federal deployment was ordered to enforce a specific Supreme Court ruling, Brown v. Board, had been handed down by the highest court in the country, and a state government was openly defying it. Eisenhower's action was, in the most straightforward sense, the executive branch doing what the Constitution requires: enforce the judgments of the federal courts when states refuse to. In 2025, there is no equivalent Supreme Court ruling being enforced. The legal authority being invoked is broader and more contested. A federal court has already ruled one of the deployments unlawful. The constitutional picture is genuinely murkier. There is also a difference in direction. In 1957, the soldiers arrived to protect a specific group of citizens whose constitutional rights were being actively violated by state government forces. The military was deployed to expand the rights of people who had fewer of them. The people being protected wanted the soldiers there. In 2025, the cities receiving the deployments are saying, "We do not want you here." The governors, the mayors, the local representatives, they are not asking for federal intervention. They are the ones being overridden. There is one more layer to this that tends to get lost in the argument. In 1957, the use of military force was bounded. Eisenhower sent troops to a specific location for a specific purpose under a specific court order. When the immediate crisis was resolved, the troops drew down. The deployment had a defined objective and a defined end. It was extraordinary in the sense that it was understood to be temporary, a correction, not a new normal. In 2025, the deployments are open-ended. There is no specific court order being enforced. There is no defined endpoint. The presence of National Guard troops in American cities has been extended, expanded, and contested through the courts with no clear resolution in sight. The scale has grown over time, not shrunk. That difference, bounded versus open-ended, temporary versus extended, is where some legal scholars locate the real divide between the two situations. Not in the legal mechanism, which is the same. Not in the political justification, which sounds similar, but in the structural character of the deployment itself. And here is the structural irony that refuses to stay quiet. In 1957, the Arkansas National Guard was first deployed by a state governor to block federal law. The federal government then took control of that same National Guard and completely reversed its mission. The soldiers who had stood in the doorway keeping black students out became the soldiers walking them in. In 2025, the federal government is deploying forces into cities over the explicit objection of the governments that represent those cities. Same mechanism. Different direction. Whether that makes the two situations analogous or mirror opposites is the question at the center of this video, and it is a question I am not going to answer for you. There are two positions I want you to hear. The first comes from critics of the 2025 deployments, civil rights attorneys, constitutional scholars, and historians who have argued publicly that the Little Rock comparison is not just imprecise, but dangerous. Their argument is this: in 1957, soldiers arrived at Central High School to enforce a specific constitutional right that the Supreme Court had explicitly affirmed. Black children had a court-recognized right to attend that school, and a state government was using armed force to prevent them from exercising it. The federal military was deployed in service of those rights. The people it came to protect welcomed it. That is the entire moral and legal weight of the Little Rock precedent. What is happening today, they argue, is the structural opposite. There is no Supreme Court ruling being enforced. A federal judge has already ruled one of the deployments illegal. The people in those cities are not requesting protection. They are the ones being acted upon by a federal government that has decided their local preferences do not matter. When a president deploys military forces without judicial backing, without local consent, and over a ruling from a federal court that called it unlawful, using Little Rock to justify it is not historical analysis. It is borrowing the moral authority of one story to tell a different one. The second position comes from scholars who argue that the critics are making a category error. Their argument is this: the constitutional principle at the heart of 1957 was federal supremacy. Faubus was a state official defying federal law. Eisenhower's response established or reaffirmed that state and local governments cannot nullify federal authority simply by refusing to cooperate. Sanctuary city policies, these scholars argue, rest on the same claim Faubus was making, that local political decisions can override federal legal requirements. If you believe Eisenhower was right to override a defiant state government, you are accepting the underlying principle. What varies is your view of which laws deserve to be enforced, and that is a political judgment, not a constitutional one. The principle belongs to the office, not to the politics of whoever holds it. Both of these arguments are serious. Neither of them is easy to dismiss. And here's what makes both of them uncomfortable. If you follow either one to its logical end, it becomes a tool that anyone can use. After the 101st Airborne left Little Rock, the crisis did not end. It transformed. The lost year, the year Faubus closed the schools, became a turning point, not because it broke the movement, but because it changed who was bearing the cost. White families in Little Rock, who had stayed quiet, who had hoped the situation would resolve itself, suddenly had children with nowhere to go. The business community, which had stayed carefully neutral, began calculating what a city known internationally for racial violence was going to cost them. Quiet people began to find their voices, not always because their minds had changed, but because the price of silence had risen. The schools reopened in 1959. Integration proceeded slowly, bitterly, incompletely, for years, and in some ways for decades. But it moved. The Little Rock Nine were awarded the Congressional Gold Medal in 1999. Elizabeth Eckford and Hazel Bryan Massery, the white teenager captured screaming behind her in the photograph, met years later and for a time worked together on reconciliation efforts. It was complicated. It remains complicated. Eckford eventually said that the attempt at reconciliation had been harder on her than on Massery, in ways that were difficult to explain but easy to understand. In 2025, the federal judge who ruled against the Los Angeles deployment included an observation in her opinion that received relatively little coverage. She noted that the Posse Comitatus Act was passed in 1878 at the end of Reconstruction, specifically to remove federal troops from the former Confederate states. The very law being cited today to challenge military deployments into cities was itself created to end an earlier round of federal military deployments into cities. History, she seemed to be suggesting, has a habit of using itself as evidence for contradictory conclusions. Here's the question that Little Rock eventually answered, and the question that right now has not been answered yet. In 1957, after the 101st Airborne arrived, a reporter asked Eisenhower a version of what people are asking today. By sending troops into Little Rock, have you established a precedent that future presidents could use for very different purposes? Eisenhower's answer was careful. He said he believed the precedent was correct. He said the executive had a duty to enforce court orders when states refused. And he said he hoped future presidents would exercise that authority responsibly. He did not say they would. That gap between believing a precedent is correct and trusting that it will always be used correctly is where this comparison lives. The Insurrection Act does not change when the presidency changes. The power Eisenhower invoked in 1957 is the same power available to every president who followed him. It does not come with instructions about purpose. It does not require judicial approval before deployment. It belongs to whoever holds the office, applied according to that person's definition of what the law requires. When a president sends soldiers into American cities, the argument for doing so is almost always the same. The law requires it, and I am the one responsible for enforcing the law. The argument against is almost always the same too. The president has become the threat the law was designed to prevent. In 1957, the historical consensus, looking back now, is that Eisenhower stood on the right side of that line. He sent soldiers to protect children from a mob that was blocking a court order. He did what the Constitution requires an executive to do. The soldiers he sent are remembered as doing something necessary and right. The question, and courts are still deciding it, scholars are still arguing it, people living in those cities are still experiencing it, is where the line is now and which side of it we're on. A soldier standing on an American street is just a soldier. What he's there for is everything. Eisenhower wrote in his memoir that sending troops to Little Rock was the most difficult domestic decision of his presidency, not because he doubted it was necessary, because he understood what it meant to cross that line, even when the crossing was justified. He understood that the power to send soldiers into your own cities is not a power that announces its own limits. That the line between enforcing the law and becoming the threat to it is not written anywhere anyone can look it up. That it has to be drawn in real time by real people under real pressure, and that the drawing of it is the whole thing, maybe especially then. You've seen a president use the military to walk 9 children into a schoolhouse over the screaming objection of a mob. You are watching a president use the military to move through cities over the legal objection of the people who govern them. Same office, same soldiers, same law. You decide if it's the same thing, the people versus 2 sides, one story. You decide.